Okay, on the record in the matter of the people of the state of Michigan versus Gino Garcia. You're right next to a mic and you're using your full voice, Ms. Shoulders. I need you to whisper because you're right next to that mic. Oh, sorry. Thank you. This is 24-00948, council appearance.
George, on behalf of people, Your Honor.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Garcia, who's standing to my right.
Okay, Mr. Garcia was scheduled for sentencing today. I did not have a pre-sentence report because it says he did not appear for a pre-sentence interview.
Your Honor, in speaking with Mr. Garcia, I'm kind of confused as to what exactly happened. He claimed that he had got on Zoom to do the meeting. They didn't get through. He claimed that he spoke with them on the phone after the fact, was waiting to hear back from them. He also stated that he went to Pat's to get an assessment, and Pat said, well, we have to have the paperwork from probation beforehand. At the end of the day, nothing got hit.
Is this a joke?
Got it. So that's what
He logged into Zoom for a meeting on the 31st and no one appeared?
No one appeared. My thing buffered for almost an hour.
Your thing buffered for almost an hour, so that means you had a technical issue?
Yeah, I guess.
Now you guess. You had a technical issue. Did you come in person?
No, I called. I called down.
And you spoke to who?
My probation officer actually picked up. I called probation because I didn't know
Who was your probation officer that you spoke to?
I never got his name, but when I called, he picked up and said I was supposed to be with him. And then, hey, we couldn't go forward with no process because he didn't have no paperwork from the floor or whatever.
From the 5th floor. He is on the 5th floor.
Yeah.
Yeah, you had some orders that was given to you. I spoke to you.
I mean,
wait a minute now. Your time to talk is over. You were here before me. I set this for sentencing. I gave you an order. I told you that you needed to report to pretrial services within 48 hours. If Dale can wait just a moment. If you can give me just a moment, because he's getting remanded into custody. I gave you orders to report to pretrial services or report to probation within 48 hours, and that you were to complete a substance abuse assessment in preparation for sentencing. We are setting sentences out 2 to 3 months. And in those last 2 to 3 months, I have nothing from you.
I did everything you asked.
Oh, well, you didn't, because I don't have a substance abuse assessment.
They won't let me take it.
Oh, okay. Well, guess what? We'll get it taken care of for you.
No
They'll be
problem.
remanded so we can get it done.
Yeah, she.
Everybody else comes in here with their assessment, don't have any problem. Did your other clients have these problems?
My
Look,
probation.
I'm not talking to you. Did your other clients have these problems where they can't go get an assessment at Pat's?
I can't, I don't recall that being an issue.
Because it's not.
I even got letters from that stating to tell y'all that I came to show.
Unless there's some confusion about him already being on probation versus.
They were saying something about
in
the paperwork
anticipation.
from the fifth floor and never made it to.
The probation, the Pat's doesn't need to work with the fifth floor to do an assessment with you.
Probation or
You need to get an assessment and then you sign a release so that it goes
Yeah, they
to
can't-
our 5th floor, but you didn't even get an assessment.
I did. I went to the fifth floor and did everything you told me.
No, the
I went to
assessment was not from the 5th floor. It was
The
that
assessment, the test.
you had to go get a substance
Yeah, they
abuse
wanted to give
assessment.
me assessment abuse without the paperwork from probation.
What
probation
paperwork?
officer. I don't know. They said they didn't know what to test me on to give me a test.
Well, if you had showed up and appeared at the time of your,
Zoom didn't work. And I
oh,
called, you know,
Zoom didn't work and you didn't appear in person. And you also think that it's appropriate to go back and forth with me too. When you didn't take care of what you were supposed to do since January. I'll reset this for April 24th at 9 a.m. By then, hopefully we'll have a substance abuse assessment and a completed pre-sentence interview. They'll meet with you while you're in the custody of the Ingham County Jail. Council appearance.
Assistant Public Defender John Lee appearing on behalf of Paula Jane Randall.
593, I do have a misdemeanor complaint here that alleges that you did allegedly commit the act in count 1 of retail fraud in the 3rd degree, and that you did, while Mara was open to the public, steal property of the store that was offered for sale at a price less than $200, contrary to NCL 750.356D4. Count one's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines. Do you understand the charges read in both files and the maximum penalty?
Yes, I do, Your Honor.
Have you ever missed court in the past?
Only for, I got supposedly I had received a notice of failure to appear for another case, but I never received anything for that. That was for the court costs and fines for the assault and battery from back in 2000. That's the only one I know of.
So you can address bond.
Thank you, Your Honor. We would ask the court to consider that Ms. Randall has lived here in the Lansing area since she was approximately 3 years old. She is engaged and intends to continue to reside here in the Lansing area. She reports that her only prior criminal offense was an assault and battery, and she was just talking about in the year 2000, which is fairly dated. And based on that, we would ask the court to consider a personal recognizance.
Oh, that was funny. I did that one. That was me. Let's see if we can go back to that. That's funny. I just deleted the whole video.
Dog
Trying to
doesn't
clean
have
up
an
something.
attorney.
I did not find a file in the public defender system.
Interesting. Dog malicious destruction of property.
Let's
He
see.
denied, it says here.
Well, that made me happy to mess that one up.
Mr. Smith.
Hello, how are you today?
I'm all right. How are you?
Great.
You say you're what?
Great today, I went out.
I'm glad to hear that you're great. I have a concern that I need to address on the record because I've had my head of security and my criminal clerk come in here today about some inappropriate things that took place in the hallway. But when you're in our hallway, sir, and you see people that work at the court or people that are visiting the court for any reason, we're not in the middle of a back alley. We're not outside in the streets. You don't catcall. You don't bother the staff with your personal endeavors. You understand that? If you're here to deal with business here of the court, then you do that. But this is not the time for you to be worried about how good someone looks, what's their name, and hey, who are you? That's not what we do at the court, okay? And don't make the court staff feel uncomfortable, okay? Act professional when you come in here. We do business here. Do you understand that? Okay. On the record in the matter, the people of the city of Lansing versus Jesse Britt, 24-03663, Council of Fair.
Jacob Riley on behalf of Mr. Britt.
There was a date scheduled for a pretrial. I do have here a plea sheet. Is that accurate?
It is, Your Honor. I was under the impression that he may have had time to attach to the file, Your Honor. If not, then we'll be agreeable with no fund jail.
Yes, Your Honor.
That's a PR file, so I don't have any time noted here.
I believe he spent at least one night in jail on arrest in this case, Your Honor. Might be the only jail for it that he has.
I don't even know if that happened. I don't have any record. All I have is that he was seen the day he was booked by the magistrate. So,
The report does indicate that he was in custody.
well, where I recognize he was likely in custody. That's not going to be a killable that works.
Okay.
It's something else. Is that what you want to do, Mr. Britt?
Yes, ma'am.
Okay, I'm assuming he's unemployed. Is that what the issue is? Are you
Yep.
employed?
No.
Oh, so raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. You're being charged with one count of trespass here from the 15th. This is on or about the 15th of December, but at approximately 11:58 p.m. You say you were getting ready to leave and they asked you to leave?
Yeah, they asked me to leave. I was getting ready to leave, and he said, 10 seconds now. And I'm, okay, let me get myself up. Nope, it's over with. Just saying, got me. And when I couldn't even get a chance to get up, start walking out the door.
And how is that trespassing?
If I can clarify, is it true that the police were called to that apartment because the person there wanted you?
Yeah, the person that actually wanted me to leave, the person had an argument, and the person stood up and told him that I just wanted him to just be quiet and whatever. And they said, well, for me to leave.
Okay, so you were visiting someone
Yeah,
at their home?
yes, I think.
Okay, and you got into some kind of a disagreement.
Yes.
They asked you to leave?
Not really, they told me to be
It's
quiet.
not really, that's not an answer.
Well,
Did they
no,
ask you to leave?
no, they said be quiet.
Okay, so they didn't say, I want you to leave my house?
No,
Okay, how, and then they later called the police?
no, they called the police. She called the police and told me to be quiet because we was arguing. And then next thing you know, police told me I'm
So-
tired.
Okay, so you called the police because you still were arguing and you wouldn't be quiet?
Yeah, well, I was quiet. Yeah, I got quiet.
Well, you must not have been assuming so because the
No,
police.
she had called him.
Okay, so she called the police arrived, she says, I want you to leave. I
No,
want him to leave.
no, the police said, I'm tired.
The police was tired?
Yeah, the police said, I'm tired. And I ain't got no tolerance or nothing right now. He said, so I'm giving you 10 seconds to get up and leave. I
Oh,
said,
so the
okay,
police asked you to leave,
exactly. And
not
so
the
now I'm
person who
getting up
owns
to
the
leave.
home.
Right.
Okay, I'm not going to accept the plea. It's not appropriate. We should set it for a final pretrial and see if we have a witness.
Really plead guilty to it.
Well, you can't plead guilty because you just tried to, and the facts don't align with guilt because it's not trespassing just because the police asked you to leave. If you left when they asked you to leave, if the person told you couldn't be there,
What
the person, and you just told me on this record that they didn't tell you that.
I asked a clarifying question, Your Honor. Mr. Baird, had the police been to that apartment earlier in the day?
they came early, I believe, one time.
And when they were there earlier, did they tell you that you had to leave and that if you did not leave, you'd be trespassed?
I guess, yes, I think she did say that. And so I just sit there and then called them again. The police came back and told me I had to leave.
The
because you
police came,
trespassed.
so the police were called earlier the same day to this address, sir?
Yes,
Okay, and they asked you to leave then?
no, they asked me to leave.
Plea failed.
Okay.
You can further counsel him, but I'm gonna set it for final pretrial. Because unless he can, he can't tell, he's already told me that the police didn't ask him to leave earlier,
Right.
that they gave him 10 minutes.
No, they had
10
told,
seconds, that is.
well, they had told me, Miss Judge, they had told me I'm trespassing. That's
I
what they said.
recognize they did. They told you that when though?
They told me that earlier. They told me that earlier.
They said, so they appeared earlier. What time is earlier?
I guess about, I don't know, was that 10 minutes before that time or then she had called him again because me and her still was kind of
Oh, so
hurt.
the police were called on you twice the same day?
I don't even know. I think they were still there.
The police arrived twice, same day? You spoke to the police twice that day?
No, the police came.
You only spoke to the police once that day?
Yes, that's what I did. But she had
So
called
how
the
did they
police.
tell you, so how did they tell you earlier to leave if you only spoke to them once?
They had told me, we had told you, because we're getting tired of coming back here.
But stop. Did you talk to them more than once that day? So how did they had told you anything if you hadn't spoke to them earlier that day?
They talked to me. I don't believe that. Yeah, they talked to me. I mean, he has the body cam and everything.
You see what this record reflects? He can't establish a factual basis. Either he doesn't remember the facts, or he's not willing to be forthcoming with the facts, or the facts, as he's stating, don't align with the plea. And if what he's saying sometimes is that you only spoke to one officer once and they told you to leave once and gave you 10 seconds, then that's not a trespass. Now, if they came earlier that day, and you were asked to be removed from the property and then you failed to leave, and then they had to come back, that's different. But you told me you only spoke to the officer once, so I gotta continue to final pretrial. That'll allow, I want the officer and the alleged victim here, person who owns this house, and then that way the parties can flesh out what happened. There's that. If the victim has a different opinion of what happened, then that'll help the prosecutor know how to move forward, okay?
March 11th at 8:15.
March 11th at 8:15.
Tank.
8:15 in the morning, you need to be here. This one matters for the record.
Nothing further.
No, Your Honor.
You're all set, sir.
Hey, everybody. Welcome to American Courts. Thank you, Anna Banana, for the gifted membership, and Nancy for the gifted membership. Thank you. That's awesome of you guys. Blue Toilet, welcome to the show. Thank you for the super chat. Thanks everybody for coming out tonight. I'm still trying to play around. The software updated, so I'm still trying to figure out the camera part of it. I just got home, so I hadn't had much time to play around with it. We got some court for tonight. Bill's such a filthy liar. Oh, Linus is calling me names in Discord, so I'm just gonna have to put up with that. We've got some Judge Kirkham. We got some more Judge Simmons. We got a Judge DeSanto and Judge McNally. Yeah, let's go to Judge McNally next. That's a good one there. We'll go to that one.
Doucette Hammond, Perlene Susan Doucette Hammond, 25U56176867A and B and C.
You stay there and let me talk to him. Stay there. You stay there and let me talk to him. I want to talk to you and I want you to know about God. I had my brothers and I had to help take them and
But as soon as I
shortly.
speak,
And let me tell you what happened with the 3 cars that he left with me. I went and got it all taken care of. And then when I got with that other guy, I hadn't got my own car. And he's the one that got me in front of my house to try. He sent the police, and the police told me to get out and drive those cars. But I didn't know that I had to get out and drive the cars. I went to the place and got them set. I don't want to get paying no money. They took all my money.
I'm not gonna make you pay any money.
Huh?
I'm not gonna make you pay any money.
Can I tell you my brothers?
No.
I can tell you my 2 brothers up and died.
John, I got it. Ma'am, just be quiet a second.
Okay, I'll be quiet.
And just tell me your name.
Huh?
Just tell me your name.
My name is Perlene Susan Doucette Hammond.
Sir, would you come up here a second? I just want to ask.
Okay, I want to come up because
No.
You don't
You
want me to
stay
come
right
up?
there. You're good right there. Honest to God, you're good
I
right
was
there.
with you before a long time.
I know you were. Not
And-
too long.
and
Sir,
see,
your name?
I don't think that
Ma'am.
the police was calling me and we talked. He told me what to do and I did what he told me to do. Go ahead. Let him talk. Go ahead. Let him talk. Go ahead. I'll be quiet.
Remind me, you're her.
I'm her son.
Yes. What's your name again?
Robert Doucette.
She was in front of me on this before, right?
No, not this.
What was she in front of me?
We had to move the car or either get it, the plates put on it or whatever.
Didn't we end up dismissing the case? Didn't the
Yes,
prosecutor? Okay. I gotta send her for a competency exam, okay? I can't, that's what I'm gonna do.
Okay.
I'm gonna set a competency.
Well, I'm in the process of becoming her legal guardian.
Okay, but
Yeah.
I'm gonna order a competency exam, Lisa. I'm not even going to arraign her right now. We're gonna just fill out a competency order and let's set it out about 6 weeks, okay?
Okay, that'd be great.
And we're gonna set it for late April, even early May, Lisa. Please don't let her drive the car.
No, I'm
with a
not.
suspended
No, we're
license.
taking her wherever she has to
Okay.
go.
And
Yes.
please, she's got to refuse to obey a police officer.
Can I say something? I drove my car all my life.
I know.
No car. I got a son in my house now. I take care
Your
for
brother.
my brother. I've been taking care of him for many years. And the guy that was going to drive me somewhere, he didn't know that I was taking care of my brother in the house because my brother is still alive. That's a blessing. And I own a house in Oak Park. And I still bought this house way up here.
Okay, my bad.
I understand
what we're talking about.
I understand.
And you got to know I'm taking care of my brother now in
I
the house.
understand. Lisa, give me a May date. Early May.
Ooh.
May 7th at 8:30.
May 7th
You
at
gotta
8.
know I'm taking care of my brother in the house.
Ma'am. May
Okay,
7th,
go.
arraignment pretrial. We're gonna send her for a competency exam. Please don't let her drive.
No, I'm not.
She's speeding. They got her going 63 and a 45. May the 7th. I'm not even going to arraign her. May the 7th at 8:30 in the morning. I think, yeah.
She doesn't drive anymore. We take her wherever she needs to go.
Please,
Okay.
please.
Yeah.
Okay, take the keys away if you would, please.
Yeah.
Unless she has valid license, but I don't think she should be driving to begin with. Thank you very much.
Okay, let's go.
Ma'am, good luck.
Okay, thank you, sir.
May 7th.
I got a patient
Come on,
with a great big white
Okay,
car.
come on.
I gotta take him to the hospital.
No, we're driving for it. Let's go.
Okay, let go, let
No, come
go.
on, let's go.
I
It's
want him
over.
to understand.
He understands.
I've been doing that all my life.
Okay,
I
let's
ain't
go.
never hit nothing. You look it up and see that I ever hit anything or get anything.
Come on.
Never. I've never done that.
Come on, come on.
Never done it.
Come
Come on,
on.
let's go. Let's
So-
go. Come on, let's go.
So if we just wait on the paperwork.
I ain't never did
You
that
get
in
it
my
done.
life.
Okay,
Never.
Thank you.
Always drove cars
Sean Nicholas Ray.
in my house for my
Okay,
son.
come on,
Take
let's
my
go.
son
Come
out.
on, come on.
Two times died.
Sir.
Okay, have a good day.
This way.
Okay, have a good day.
Yeah.
Let's go. Come on. Have a good day.
He felt like that was speed dating for him. That was a busy one.
This is yours, isn't it, Mr. Paul?
Yes, I'm sorry, Judge. I had a case with Perlene.
No worries.
Above ground swimming pools.
No worries. Your appearance?
House Counsel Attorney Mike Baldwin, P 65417 on behalf of Mr. Sean Ray.
Mr. Ray, your name again?
Sean Nicholas, right?
So this is an animal abandonment.
It is, and we have had an opportunity to.
It was
review the
pled
case.
under 77.1. I'm gonna go ahead and listen to whatever you have to say. First of all, is everything in the report accurate?
Everything is accurate and correct. There's no deletions, corrections, or errors. And I'm going to ask the court to consider deviating from the recommendation. Judge, this is a situation, my guy, my client, he raises these rabbits. They're a special kind of breed. They're actually, they're a little more, they have thicker fur. They're a little more rigorous. And he travels for work and things just, he lost control over his schedule. And unfortunately, this situation happened. He takes responsibility. I don't see the need for psychiatric evaluation and mental health treatment. I'm going to ask the court to strike provision 3. And moreover, Your Honor,
why in the world would you leave rabbits outside without a heat lamp and let one die frozen to death for a month before anybody even came? Why in the world would you do that?
Well, first of all, Your Honor, there are neighbors that
I know,
are
I read the
mentally
report.
helping. So it's not like, it's not textbook. He knew that the neighbors were there. They had this straw that they can be under. Again, this isn't your common bunny. These are breeding bunnies.
I don't care if they're racehorses. The point is, he left them out there and they died.
They did. It was an awful situation.
What are you doing?
He has no marked criminal history, Judge. He understands that this is not good. And he has vowed to have more consideration.
He's not going to own anymore. Listen, your rabbit racing days are over. Okay? They're over.
He can live with that, Judge. He has no, he's not in possession of any other domestic animals. He understands what he did was wrong. And because these animals suffer.
It's cruel.
Fair enough.
It's cruel. I mean, I don't care if he's making money off of racing. I don't care if it's the fastest rabbit in the world.
Well, no,
I really
he's
don't.
not, I don't think he's bringing them for that reason.
Whatever. You said they're racing rabbits. I never heard of racing rabbits. Maybe there are racing rabbits. I've never turned on TV and seen a rabbit racing down a football field or any other place. What are you doing?
Sorry, Your Honor. I went to Jersey. Prior to this happening, I went to working.
You know, who was going to feed the rabbits? Who was going to eat the rabbits? Who was going to care for the rabbits?
2 weeks prior to this, I left them 2 quarts of food and 3 gallons of water. And when I came back from work, they still had plenty of food and water left. I was at home for a week. The rabbits were fine. I left for 2 more weeks and.
You're too irresponsible then. Really?
No more rabbits, Judge.
No more anything. It's ridiculous. I mean, I can't believe that this kind of thing goes on.
Again, he has no more criminal history, Judge.
I know. I'm not putting him in jail.
He made a mistake.
No, he made it more than a mistake.
Okay, Judge.
I mean, this is not.
It's cruelty to animals.
A mistake is if I forget to lock my door. That's a mistake.
All right.
If I leave my car running outside on my driveway in the middle of the winter and somebody that was a mistake. There's a lot of mistakes. This is not a mistake. This at best is complete gross negligence. That's what this is. It's silly.
Yes, Judge.
I don't know why people have pets if they don't want to care for the pet. You don't want to care for the pet, don't own the pet. Don't possess the pet. Don't buy the pet. Don't have it anywhere near you.
Yes, Judge.
Anything else?
I'm going to ask for 6 months of probation, Your Honor. Allow him an opportunity to show that he can correct this and it won't happen again.
12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're not the owner possessing dogs, cats, bunnies, or any other domestic animals. You understand me? In the next 12 months,
sir.
You're not to own, possess any dogs, cats, bunnies, rabbits, or any other domestic animals. Do you understand that?
Yes, Your Honor.
100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4, screening fees 60 for 380, 385. Probation fees are 240 for 625. Serve 2 days on the court work program, that's 695. That's $35 a day charge. 1 day of community service by April the 20th. So your total fines and costs with everything here amounts to $695. You may be eligible for early discharge. I am taking this under 771.1. You're not the owner possess.
He won't.
Dogs, cats, rabbits, any other domestic animal. Do we understand one another?
Yes, Your Honor.
I'm not going to order psychological treatment.
Thank you.
But I probably should, to be honest with you. Can you pay all this today?
Yes, Your Honor.
Give me a review date in 12 months, Lisa, please.
March 4th at 9 o'clock.
March the 4th of 2026 at 9 o'clock. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. You'll meet with probation before you leave. Good luck. Thank you. Terrell, Javon.
So I had to think about racing bunnies too, because at first I was thinking racing rabbits as in you put the rabbits next to each other and they race, and someone mentioned that no, they get chased by the dogs, so that makes sense. Looks like we got Andrew in the crowd tonight. Hey, Andrew, I see a lot of names that I know and recognize, and thank you so much for coming out. Sometimes people disappear off of the grid, and we don't know where they're at, and you start worrying about people, and sometimes you see names pop up, and you remember you hadn't seen them in a while, but life just gets in the way, and sometimes it gets past, but. It's awesome to see y'all out there, and it's good to see everybody chatting away. Be nice in the chats. Be nice in the chat. Sometimes the mods have to delete something. If they delete something, it's not you. It's me. And so let's go to Judge Simpson. I think this is a landlord one from yesterday. I had one that had a couple of goofy ones. There's a pretty good one from yesterday. That I'll probably do tomorrow night. We're not going to have time tonight, but he had a good landlord docket yesterday. So here we go with that. Yep, this is that one.
Do me a favor, can you go out there and just make sure they don't
That was the ending of one. He was so frustrated with it, he wanted to make sure that they didn't fight out in the hallway, and so that's one we'll show tomorrow night. That was an entertaining one. It's kind of a part 2 of one. So. I want to show the first part also.
I'm done. I'm so done. Yeah, here, you take it. All right, let's try this one. I can't let you have it if you're not gonna be unbiased. All right. Danetta Masick versus Lula Williams.
Good morning. Good afternoon, Your Honor.
I love how the judge gets
Happy
on the mom in
Friday
this
to
one.
you.
It was.
We're gonna make this easy.
Okay.
We have come to an agreement.
Yeah.
You guys want to put your names on record?
Donetta Masik.
My name is Lula Williams. I'm her mother.
Okay.
Wait, Dennis, on behalf of Ms. Williams, we've come to a conditional dismissal. Ms. Williams is gonna be out by Monday, end of the day, March
This
17th.
Monday coming out.
Yep.
All right. And then if she's not, then do I have the paperwork on the
Yes.
conditional?
Yes, and I
Maybe.
checked the box for the immediate.
Oh, I do have it.
For the immediate writ, which I usually don't do with our regular landlords.
Pardon?
I say I checked the bottom box, the one for the immediate, all she has to do is put in her, an affidavit.
Right,
order,
an affidavit.
And
the
then a
judgment,
writ.
and then- And you understand that, ma'am? That's what you would have to do?
Yes.
All right.
Okay.
And since you're the unrepresented party, do you have any questions regarding this conditional order dismissal?
Just about court fees or anything else I had to pay or did need to be paid.
I have what's on here is I have no court fees or anything. I have nothing in terms of any monetary amounts.
Okay.
What this just indicates is that the defendant will be moving by March 17, 2025. If she doesn't move, then you would need to file an affidavit with the court as well as a judgment and an order of eviction. The court would sign off on that. And then at that point, she could be forcibly removed from the premises. All right. All right. Again, since you're unrepresented, I would indicate to you, you do have 3 business days to think about this. If you believe that there's some right you didn't assert, some misunderstanding or some confusion on your part, you'd have to file a motion with the court within that time frame. Doesn't mean I grant it, but you'd have that time frame to do that.
Okay.
Okay? Any other questions?
I have one.
Yes, yes, ma'am.
I just want to have a clean and comfortable move out of my daughter's house. I've been there for 2.5 years now, and I just want to be peaceful because I have been, and they just say.
Okay.
We'll address.
So and I think this provides for a clean move out, provided you do that by Monday.
Could they stay away from me because they come to the house a lot?
I can come to my house. No, thank you, ma'am. I have things that I need to fix so that we can move back into our house.
So technically,
My daughter's
Go
room
ahead,
window
I'm
was
gonna be
broken
quiet.
out. So I will be getting that fixed this weekend.
Your daughter did it. I didn't do it.
Okay, Your Honor,
Okay.
we'll
You guys
resolve.
want me to sign this or not?
Yes, go ahead and sign it so I can
Thank
go.
you.
I'll
But
call
you
you.
know, I
You
just
want me to sign it?
Mhm.
All right,
Go ahead and
great.
sign it.
This case is conditionally dismissed. You guys have a beautiful weekend.
Happy Friday, Your Honor.
Yes, ma'am. What? No, I think that'd be okay, maybe. I don't know. Just not getting better. Third time's the charm. Legends Grove Apartments versus Sobe Ekar.
Good afternoon, Your Honor.
Max Fieldmutter on behalf of plaintiff, Your Honor.
And your name, sir?
Sobe Ashker, Your Honor.
All right, where are we on this case, folks?
We don't currently have a resolution on this one, Your Honor. At this time, management's indicating that there's a balance owing in the amount of $12,427.68. Court cost the amount of $180, giving us our grand total of $12,607.68.
Your Honor, I'd like to address the rent first. The rent was paid. I went ahead and submitted documentation. Also, I confirmed.
What rent was paid? This amount?
I owe for, 'cause technically I gave you paperwork that says how much I've paid so far as rent that Legend Grove has received, which was $19,775, which when you divide it by the base rate, it ends up being for 9 months. And technically I was there for 10 months if you're gonna include March. So I would only owe them the balance for
Counsel,
March.
did you get a copy of what was filed with the court?
I'm sorry, Your Honor, I missed that.
Did you get a copy of what the defendant filed with the court regarding his
No, I have
payment?
yet to receive it.
Your Honor, because I didn't even get served correctly.
All right, everybody, I had to look it up because there's some talk in there about how old the judge is. According to Google Brain, it says, while Judge Cedric Simpson's exact birth date isn't publicly available, he was in private practice until 1999 and earned his doctorate from University of Maryland, returning to Michigan in 86. Based on this information, it's safe to assume he's in his late 50s or early 60s. So he's in his 50s or 60s according to Google, and you know Google's never wrong. So, all right, well, let's go back to that.
When I asked for the ledger, when they gave me the I think it was $10,000 ledger, I had noticed that there's a docket number on there, and I had to do the research on myself. I don't know, with all due respect, Your Honor, to this court, like, I don't even know the attorney's name. How am I gonna reach out to him? Like, if I don't know who's representing them?
All right, so let me stop you there. So what I'm going to do is I'm going to give you if he were to use Mr. Landau, he can reach you through that, correct, counsel?
I'd prefer to provide different numbers so you can reach me directly.
Okay, so do this. Put that in the chat. That'll go to my staff, and then we will give that to him. What I will then do.
Your Honor, I'm sorry to interrupt. I tried to reach out to the Legends Grove via email to go ahead and get an updated ledger for the 12,000, as well as get his email contact information, but I'm blocked.
Okay.
So I wanted to.
Just listen. I'm not at this point going to worry about what happened with the communication. I'm just going to try to foster the communication.
Thank you.
So that the parties can at least talk. If you disagree, you disagree, and then you got to do it. But I don't even know if everybody's in disagreement at this point in time. You provided certain documentation, this documentation to the court, right?
Correct.
And so what I'm going to do is, and I know this is unusual, but let's do this. We're going to give you the phone number so you can reach counsel. Let's scan and get. What I'm going to do, counsel, is we're going to scan this, send it to you. Okay, so that you at least have that. Okay.
Thank you.
And then I'm going to adjourn this out to the 21st, 2005 at 2 p.m. Yeah, welcome aboard on that. All right.
Your Honor, can I just say something real quick? I gave you the documentation because obviously, you know, I respect this court and I respect everything, but as far as from a Legends Grove aspect, their credibility is in question because they're changing dates on documents, and I don't want them to have it.
Sir, I don't know any of that. All I know is that you filed something with the court, they don't have it.
I understand, but if they're changing the dates to manipulate them, like when they come back to court, obviously they're being represented by counsel, so they have an advantage as it is already.
Did you want to get an attorney, sir?
I'll just be quiet. I'm sorry.
No, do you want an attorney?
No, it's not.
You can always get an attorney to come in and represent you.
I understand.
All right, but you can't file things with the court without the other side receiving them. It's same thing would have to happen if counsel were going to file something with the court. They'd have to make sure to try to serve you with that. Okay?
I understand.
So I'm just trying to foster that to happen because it hasn't happened.
I understand.
Which means that even if you call him, you guys aren't going to be having a discussion because who's looking at what?
Right.
Okay? So I'm adjourning it out to the 25th, 2 p.m. We'll send these copies over, and then you guys, and we'll give you the phone number. You give them a call, and let's see exactly where we are.
Sure.
Next week.
The 25th at 2 p.m.
21st.
21st.
At 2 p.m.
Okay. Thank you,
Your Honor.
Thank you.
Before,
Yes, sir.
Before passing on this matter, this might be wishful thinking, but management's unsure of whether the defendant is still at the property or not.
No, I'm not. Every,
Not in the unit?
no, nothing. And then the keys and everything are in the kitchen. I left
Did you?
because they know how important it is.
Well,
I don't want the
sir,
eviction.
sir, if you're not in the unit, you voluntarily surrendered, did you turn over the keys?
I gave them everything. Yeah, everything's on the kitchen counter.
So management wasn't aware of the surrender of the keys being on the kitchen counter. So we weren't sure if we had permission to retake the property. They were just under the impression that he may have.
Okay, so here's what I'm gonna do, because they're only asking for possession of the units.
They have it.
Well, stop.
I'm gonna shut up.
Guys,
Okay.
do that. They're only asking for possession of the unit. If you've given them possession of the unit, there's no reason for me to have a case here.
I understand.
So here's what I'm gonna do. Counsel, under the court rule, I'm gonna give you permission to enter the unit, your client's permission to enter the unit to inspect the premises for any waste or damage. If you have the keys in there, he's indicating on the record, you're voluntarily surrendering the residence. You can take possession, and then what I'll expect is a dismissal of this matter.
Understood, Your Honor.
But I'll leave the date in place in case it doesn't happen that way. But if you've left, there's no reason for me to send these documents. So I'm gonna wait on that too, counsel. All right.
I understand, Your Honor. No problem.
All right.
Your Honor, is he gonna contact me on my cell phone? Does he have that information?
Contact you regarding what?
So obviously, I left the premises. That's gonna be verified. So how am I gonna know if I should come into court next week or not?
Okay, so we're gonna give you his number.
Oh, okay.
Give a call sometime next week. Ask him, are you guys dismissing?
I understand.
If they say no, you gotta come here. If they say yes, they'll dismiss.
I understand. Thank you.
All right, thank you.
Thank you. Have a good day.
So that guy's $12,000 behind on rent. He leaves and doesn't tell him he leaves. He left everything on the kitchen counter and is arguing with the judge that he shouldn't have an eviction on his record because he left everything on the counter but didn't pay the $12,000. And so I'm trying to figure out what kind of places he got where he can get $12,000 behind. I certainly don't need to rent anything that expensive.
Thank you.
Thank you, Your Honor.
Thank you, counsel.
Not a problem, Your Honor.
Court calls the case of Arbor.
And another thing, I don't think they're allowed to go in. Like this lawyer was asking for permission to go in and check things out. I don't think they're allowed to go in unless they get an eviction on it. So, unless he turns it in, it's still their property. So, I don't know. I'm not landlord, nor will ever be.
House Apartments versus Jasmine Branch.
Max Fieldmuller on behalf of plaintiff.
Hi,
Hello, what's your name?
Jasmine Branch.
You want to yell at me too?
No,
Okay, I'm just checking before I go ahead. All right, where are we on this case?
So you have to have a resolution on this matter. We've got a rent to retain in the amount of $7,527.24. Court cost amount of $180, giving us our grand total of $7,707.24.
All right.
so I have 2,000 today. I had an appointment with Hawk today and they're
I'm
gonna,
sorry, that first part you said?
I have 2,000 right now. And I
Okay.
had an appointment with Hawk today and they're gonna email them and everything. They're gonna pay the 3,037. And then I'll have the rest in 2 weeks, if that's okay.
Okay, so that I'm clear. They're gonna email the landlord because they need the landlord.
Yeah, they said in
information
14
regarding-
days, they're gonna send a check to them.
Okay, so. Gotcha. And you have 2,000 a day, is that cash?
It's cash.
You
I have to go get
2,000
a
in
money
cash?
order.
Okay, so here's what I'm gonna do, counsel. And then they've got to get information and then you said you'll have the
rest in 2
if
weeks.
they pay the 3.
I'll have the rest in 2 weeks
And have the 2, then you'll have the rest in
for this month, right? Yeah, in 2 weeks.
Okay, so all right, just follow me here so that I'm clear. You can have everything cleared up through March with the assistance of Hawk.
Yes.
Right, okay, so here's what I'm gonna do. And this may be over the objection of plaintiff, but I'm gonna give her a shot. But you take the 2,000 that you have
Okay.
and I want you to deposit that in court escrow.
Okay.
Okay. So the 2,000, because what's gonna end up happening is come the 28th. Well, Hawk is not gonna pay unless they're sure that the balance is at the 3.
Okay.
Okay, so you go up to the counter, pay the 2,000 into escrow.
Okay.
All right, and then I'm going to adjourn this out, council, 2 weeks to the 28th. I'm gonna give her a shot since she went over with Hawk. Give them time to send the information to Hawk, get a firm answer, and let's see if we can get this all worked out.
Okay.
How's that sound?
That's fine.
March 28, 2025 at 3 p.m.
Okay, thank you.
Okay, so the balance of the payment, and if I just do this here, is gonna be about, so 5,000 comes off of that. It's gonna be about 2707.24. You will have that at what point on the 20th?
In 2 weeks.
Pardon?
In 2 weeks.
On the 28th?
I have it on 28.
Okay, so what may have to happen, because I don't know that Hawk's payment will go over. I'll need you to bring that down and put that into escrow.
Okay.
All right, that way we've at least got it. What's your monthly rent?
$15.99.
Okay, so just so you're gonna get that paid probably in the next 2 weeks after.
Yeah.
Gotcha. Okay, I see what your plan.
Yeah.
Okay, so do that, they'll get that, and then we'll see everybody on the 28th.
At
You
3
should
o'clock.
be in pretty good shape
Okay.
to try to get it done. They're gonna need the commitment from Hawk that they'll
Okay.
do that if it's at the 3.
Okay.
Okay, sound good, council?
Not a problem, Your Honor. Do you need me to submit an escrow order?
No, we'll be good. They'll take her money and we'll have it here. We're good.
Okay, good. Thank
Okay. Ma'am, thank you for coming up,
You're
and
welcome.
having a plan and being pleasant. I do appreciate it.
You're welcome.
All right.
Agreed, Your Honor.
Yes. All right. And does he even know? Yes. Harbor House.
All right, that was it on that one. Thank you, Nancy. Thank you, Jennifer, Fozzie, Kathy, and all that. Thank you guys so much. I was talking with somebody that's important to me today, and I was talking about how uncomfortable I am about super chats and memberships and all that stuff. Because, in the end, we do this to be a community. We don't do this to share money. We don't do this to throw money around. And he gave a real good explanation for it. He had made a comment about it. It keeps the lights on, and that I can't begin to tell you how true that is, and how humbling that is. And we do appreciate it. It's certainly not necessary. It's unexpected every time, and it's kind of awesome. But we actually, one of the long lost mods got gifted a membership, so we gotta go find her and see what happened to her. So, but I greatly appreciate it, and I know the mods really appreciate all the all the support the channel's gotten, and we're gonna keep going and going. And I think we got Judge Kirkham. I was actually scared that he stopped. I was afraid that he stopped streaming, but nope, he's back and streaming, and so we got good Judge Kirkham. And you're right, Carlos. I do I work a regular job, and so this is kind of on the side, and this is afterwards. But it absolutely takes up a lot of resources and time. And me and my wife talk about it all the time. About you put a lot of hours into it. Luckily enough, we don't track the hours because we don't want to go crazy. But it certainly does take some time. So let's go Judge Kirkham and watch him for a bit.
Okay, so now this is 2017 3712 DS April Adams versus Gaffney Hilliard. It is 1:42 p.m. Wednesday, March 12, 2025.
Good afternoon to both of you. The court will note that this matter is before the court on the front of the court's petition to show cause why the plaintiff, Ms. Adams, should not be held in contempt of court for a denial of parenting time. There was a denial of parenting time complaint filed by the defendant stating that he'd been denied parenting time from December 22nd, 2024 through December 29th, 2024. And that the plaintiff had not shown at the police department as provided for in the prior orders of the court. I would note that the referee had entered an order back on January 23rd, 2025, where the referee found the plaintiff was in contempt of court for denial of parenting time in September, October, November, December 2024. She was assessed court costs of $100, and the hearing was set for today. So what we're going to do is I'm going to take testimony from both of you. Mr. Hilliard, I'll have you raise your right hand, be sworn in.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do. Okay. As long as you speak up, you can testify right from there, sir.
Okay.
Tell me, you filed a complaint for denial of parenting time. Tell me what parenting time had been denied.
I filed a complaint for being denied parenting time from May 2023 until last week. The first order, the first custody order was dated January 2017 or 2017. And it went out the window in October of last year. And we got a new order granting me joint custody. I have not saw my child since May 8th, May 9th of 2023. Well, I did see her in school. I went to school to see her, and I stopped going to, I saw her once at school, and I stopped going to school because I didn't know what type of, after speaking with the administrator and the teacher, I didn't want to confuse the child anymore. And I stay away from the child for that matter, because I don't want to confuse her anymore, because we have a great relationship, me and my child. However, Miss Adams just, for some wild reason, refuses to allow us to have a relationship. Now, it's been noted that Miss Adams has accused falsely me of abuse, of domestic violence. I was arrested, released, charges not filed because of investigation found there was no domestic violence. I've been accused by Miss April Adams of abusing my daughter in some type of sexual nature with the video that was investigated by the Battle Creek Police, friend of the court, and CPS. And it was actually stated in the custody order that Miss Adams had actually violated the law by sending the video to my sister in Georgia. Now, I didn't pursue charges through the prosecuting office to hurt her in any kind of way, because this child needs both of us. This thing had caused me to go into substance abuse for a period of 2 years.
Okay, sir. Well, I'll let you go on, but substance abuse is a choice. There's
Yes,
nothing
exactly,
she can do
exactly.
that's going to say you have to get into substance abuse. So
Well,
I'm going to disregard that.
We'll disregard that. However, I did get treatment, and I'm still in treatment today. I see a therapist twice a week, and I've been doing that since November the 9th, 2023. And I just want a relationship with my child. I want my parenting time. I want my parenting time that was missed. I would like it made up, because this is just ridiculous. It hurts the child. It no longer, well, yeah, I don't like it. I don't feel good, but I'm not going to jump off the 36th floor about it.
Okay.
Did he just say he's not going to jump off the 36th floor for it? I don't know that I've ever been in a building with 36 floors. I don't know, but it seems like they'd be a long ways to fall.
Court notes, and you had mentioned sometimes there was an order regarding custody, parenting time support, and contempt, in which the court awarded through the referee at that time. There was a referee hearing in September and October of 2024. The order having been entered on October 22nd, 2024, which awarded you joint legal custody, physical custody, and physical custody. And it provided for parenting time in alternating weeks and alternating holidays. And there was another referee order, as I said, on January 23rd, 2025, which held her in contempt for denial for those particular months. And you're saying that since, because it's the last one under the January order would have been sometime in December. So you're saying in basically January and February as well, you've been denied parenting time?
Not only that, but I'm also saying I have been denied parenting time, period. I haven't received 1 minute of parenting time since we've been separated.
Well, let's focus with me. I'm asking you January and February
Yes.
this year.
Yes.
Okay. And I would assume anything in March.
Nothing.
Okay. Thank you.
You're welcome.
Ms. Adams, do you have any questions of Mr. Hillier?
I have so many questions, but that can't be addressed here today.
Okay.
I mean, but yes, I have a lot of questions.
Well, this is your time. If you have any questions concerning the denials, this is the time to ask them.
I mean, Your Honor.
Okay, I'm going to let you have a chance to testify in a moment. I'm just asking, do you have any questions?
No, Your Honor.
Okay. Now, ma'am, what I'll do is have you raise your right hand, be sworn in, and then we'll proceed with you.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes. I do.
What would you like to tell me, ma'am?
Your Honor, we was together, when I had my daughter, I decided to stay with this man. I knew about his past addictions, I knew about all that. I know that's neither here nor there, but it does play a role in what's going on. I left him when our daughter was 2. He got back on drugs, as he stated himself. But we separated. This time around, he got clean. I decided to help him. He went to check himself in the VA. I said, okay, we'll watch your house where I used to once live. I will watch your house. I will check your mail. You know, I agreed to that because I had my daughter, my dad in my life. So I know the effect that has on a child and a girl at that. So I helped her dad so he could be back in her life. And he got off drugs until he came back home. I have no proof as to whether he was using or not. I just know his behavior changed. I went back to my apartment, which I had, but before I did that, I found some disturbing videos in my daughter's phone sent to her dad, which he just spoke about himself because he said I accused. I didn't accuse him. I sent him a message asking for some type of clarity because my daughter don't do things like that. I mean, they're disturbing. I don't know if I can address that here. I don't know if I can even say what it's about because I don't want to get in trouble, but they were disturbing. There was an investigation. Mr. Hilliard went and hand over his phone. I handed over mine. I handed over my daughter's as well. The investigation was closed. I have no clarity on that situation, but that's how I'm withholding parenting time.
Stop. Who did the investigation?
The Battle Creek State Police. Emmett came first because where I live in my apartment, not as.
Okay, so Battle Creek City Police?
Yes, sir.
Okay. And you said, and then you said Emmett did an investigation or not?
Well, no, Emmett came because technically I'm on the cusp of like downtown and I'm on Keenan. So I know you're familiar with your but so it's like Emmett came first, but then the Battle Creek Police and everybody came on Mother's Day.
Okay, okay. Doesn't matter when they came.
I know, I'm sorry.
So Emmett Township, because you were there, did they do an investigation?
No, the Battle Creek Police Department did.
Okay. And I think he said that CPS had investigated as well. Did CPS do an investigation?
Yes, sir.
Okay. And I think because we haven't heard anything that city police and CPS didn't find anything, did not substantiate. Is that correct?
Yes, sir.
Okay. And I understand why you may have some issues when if these things come up, it's justifiable that you're concerned, but if you want to change a court order, you have to come into court to do it. You can't do it unilaterally on your own, okay? Because that order still stands until it's changed. What else would you like to tell me?
That's it,
Okay, then tell me, because clearly the referee had previously held you in contempt for denial of parenting time for, again, periods of time through September through December. And now there's the denial as it relates to January, February, March. Why have you not allowed that parenting time?
it's
What?
I mean, just the personal, if you've seen the videos, Your Honor.
Well,
I'm
presumably,
concerned with handing over my daughter to somebody. It's too late after something happens again.
presumably the police and CPS all saw the videos. Is that correct?
Yes.
Okay. And they weren't concerned enough to take action on it. And I'm not saying that they shouldn't, but usually they're very vigilant on these particular types of things. You understand? And so you do not dispute that you've kept the child from him, at least in January, February, and March.
Yeah.
So it looks like basically 5 weeks worth of parenting time. Is that accurate?
Yeah.
Okay. Hold on, sir, I'm not done.
You gotta love that raising his hand in court. Yeah, that's just great.
Okay, anything else that you'd like me to be aware of?
No.
Okay. Now, sir,
Other than Mr. Hilliard did just go to jail for dropping dirty on drugs. They say he's with Michael Horn.
okay.
He's on probation for a DUI. Yeah.
Okay, well, we can address that. Go ahead, sir. What else would you like?
Okay, just to address that, I drop voluntarily through the VA twice a week, every Monday, every Friday. I have all results right here. Well, at least in November, December, January, February, and March. Another thing,
Okay,
our phones, my daughter's phone was turned over. April's phone was not turned over. My daughter's phone indicated that the email or text message was sent to her phone and then to my phone back to back. That's why I called the police. When I called her on Mother's Day to wish her a happy birthday, and I got the message right here on my phone where she tried to use it and jack me up with the court. It's written in text. We'll see what the court thinks about it. I immediately called the police.
okay,
And so
okay,
this is innuendo bullcrap.
okay. Anything else germane to this particular hearing, sir?
This particular hand, I would just like my parenting time.
Okay. And ma'am, anything else that you have?
I'm just really concerned. I never got no clarity on the situation, if it was or it wasn't. It'd be too late if I did. And to see his still now his behavior back into drugs and blaming me for drugs.
Okay, one more thing.
Hold on.
You know.
Well, you understand that he does have drugs test as he said, every Monday and Friday through the VA. You aware of that?
I am.
Okay.
Is there?
And he has the test results there, as he states, from, I guess, November, December, January, showing that they are that they're negative. So I understand your concerns, but you have to have facts and evidence when you come to court. You just can't make wild accusations. Anything before the court makes a ruling.
I'm just trying to protect my daughter, Your Honor, and this man is on probation for a DUI. Granted, people change and he does still drop okay, but he just dropped dirty and went to jail a week ago, or a week ago. Then is also on probation for assault and beating a girl in the head with a shovel. Why would I have my daughter? Yeah. Okay.
And what happened is to present all that, these are just accusations you're making. It's not evidence until you have proof of these particular things, which you have a right at any hearing to bring proof, bring witnesses, bring exhibits, et cetera, which you have not done. So the court can only accept what your testimonies are in this matter. Okay?
Yeah.
It does appear in this case that the court has referenced the orders that have occurred. There was an order of October 22nd, 2024, which provided with the parties joint legal and physical custody, that they were to have alternating weeks, alternating holidays, and that there had previously been a finding of contempt as well back on, or from the referee back on January 23rd, 2025. In this matter. So clearly, man, you have been in contempt in this case. And as a result, based upon the testimony before the court today, the court will find that you in fact are in contempt of court for denial of parenting time. And the referee had previously had not ordered any makeup parenting time in this matter, simply held you in contempt and had in fact assessed some cost at that prior hearing leading to the January 23rd, 2025 order. What the court is going to do, ma'am, is at this point is you have to turn the child over to the defendant. And what the court is going to order at this time is, because I'm not going to go back beyond the prior order saying that he's entitled to his 5 weeks of makeup parenting time and his regular weeks. So it means he would have the child for 10 weeks straight because of that fact. What the court will do, ma'am, is at this point, the court is going to remand you to the custody of the Calhoun County Sheriff. And what will happen is you will remain in the sheriff's custody until the child is turned over to the defendant. Okay? So what will happen is you're going to have to get a hold of somebody to get the child to the defendant so that he gets his parenting time, which will be 10 weeks. And then after that 10 weeks, then we'll go back to the alternating weeks as the order states. So until that occurs, if in fact the child is not turned over, then you will remain in the custody of the sheriff until such time as the child is turned over. Okay? That will conclude the hearing. What, sir?
Yeah, and I spoke with the administrator and my child's teacher today, informing them of this hearing or this court appearance today. And I can go pick up my child from her school.
Certainly, you can. So what will happen is the plaintiff is going to have to go to the sheriff, the company of the sheriff at this point in the custody. And once you've been able to pick up the child, you can contact the sheriff's department and confirm, well, you're probably going to have to come down here because we don't want phone calls, because anybody can say, this is who I am, and yes, I've got the kid. So you'll have to probably come down, confirm with the sheriff, give them ID showing who you are, and confirming that the child is in your care. And at that time, the plaintiff then can be released from custody.
Understood.
Okay? Okay, thank you. Well, that will be the order of the court. You're free to go. Have a good day.
Thank you.
And I hope everything works out after this point.
May I call somebody or
Excuse me?
try to get a hold of somebody?
Well, they'll let you call somebody from the jail at this point. So.
I have a car.
All right, I bet y'all didn't think that was coming. How often do you get to see that happen? I truly actually hate for anybody to go to jail, but she certainly worked for that one. She earned that visit. I'm gonna try to find the judge. Try to find Judge DeSanta one to get us out of here. Let's see if we can find Judge DeSanta.
On the record in the matter of
there we go.
State of Michigan versus Zachary Wick, 25309. And Detective, your name for the record, please.
Chris Zabel, Your Honor. Good morning.
Good morning. Can you hear me okay?
Yes, ma'am.
Yeah, okay. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth? Okay. And counsel, detective, if you may proceed on the warrant.
Thank you, Your Honor. On 3/9/2025 at approximately 9 p.m., the defendant, Zachary White, was drinking and got into an argument with his 13-year-old daughter, Layla, in which Zachary slapped her in the face or on the cheeks with an open hand. Jeremiah and Samantha were in their home's basement doing laundry when all of a sudden their daughter ran downstairs and advised them that Uncle Zachary slapped Kayla. Jeremiah and Samantha went upstairs and Jeremiah attempted to intervene. Zachary told him, which is his brother, that he was having a one-on-one talk with his daughter. Samantha got Kayla inside the house and Jeremy locked the door with Zachary outside of the home and told him to leave for the night. Zachary forced entry into the home and damaged the storm door and the inner hard door. The two brothers fought, ergo, the domestic violence won unto Jeremiah, brother and brother, who currently reside together. And prior to that, a DV on Kayla, father, daughter, with the additional note, a criminal history of a conviction for domestic violence.
All right, thank you. Upon examination of the complaining witness. Oh, I'm sorry, detective, there's also a third offense notice?
Third offense notice, yes, Your Honor, which is a 5-year felony with that prior conviction in 2023.
All right, upon examination of complaining witness, I find that the offenses charged were committed and there's probable cause to believe the defendant committed those offenses. And counsel, your appearance, please.
Yes, Your Honor, John Goldport, P 30758, on behalf of Mr. Week.
Thank you. And Mr. What, your name for the record, please.
Zachary White.
White, I'm sorry. Record. Counsel as to bond.
Your Honor, well, first of all.
I'm sorry, it's the arraignment.
Your Honor, it's my understanding that there is a third offense notice, thereby making this matter, I believe, felony. However, I raise this because it appears that there are two separate victims. I'm just making this for the record, with respect to the initial charge. One being the brother of Mr. Week, and who he resides with. And second of all, his daughter, the defendant's daughter, is my understanding.
Okay.
The prior conviction was approximately 2 years ago, is that correct?
No.
Oh, I'm sorry.
April of 24.
Oh, April of 24.
I'm showing that he pled guilty to domestic violence second offense.
Oh.
The felony, assault with a dangerous weapon, 2 counts, and another domestic violence second offense matters, those were dismissed. And then he started probation April 17th of 24 with the Third Circuit Court. Would that be accurate, sir?
Sorry?
Is that accurate? You're still currently on probation?
Yes, Your Honor.
That matter was out of Southgate, is that correct, John?
No, why not?
Oh, I'm sorry. I know he
The
doesn't.
Southgate matter from July was an OWI, well, operating while visibly impaired, also while he was on probation.
Because the way I was reading it, I didn't realize that it was a domestic violence second offense that he was on probation for.
Yes.
That would mean that he had one prior to that date. That's what
Minimum of one prior,
a
correct?
minimum. That's what confused me when the only one that was cited for the third was just one offense. That's all. So with that said, Your Honor, we waive a formal reading of the charges. He would stand mute to the charges and ask the plea of not guilty be entered.
The court will waive the formal reading. Counsel as to bond.
Your Honor, the court is well aware, this is not his first involvement with the criminal justice system. He is, as you've noted, presently on probation to this court, it appears. He's also, I believe, on probation into Southgate. Is that correct, sir?
That's correct.
He is gainfully employed. He's worked as a machinist for approximately 10 months. He is residing, or at least was residing with his brother at the Wyandotte address. We're asking for a bond. I'm sorry. We are asking for a bond which can be reasonable under the circumstances, understanding that he is on probation, both to this court and to other matters.
What are the current terms of your probation at the Third Circuit Court?
I'm seeking better counseling and with Motor City Center of Hope for Lincoln Park, and for Southgate I'm with the Guidance Center. I'm in substance abuse counseling, regular mental health counseling, and I've been going to AA meetings, and I just started this new one with the Guidance Center. Everything was going pretty well. I'd like to continue and seek help with the issues I've been having. So, yeah.
Sir, you said that you were enrolling in batterers counseling. Did you already do that?
I'm sorry, what did you say?
Your batterers counseling, did you complete that condition?
I'm currently doing it right now.
Well, why did it take you so long to start it, sir, since you've been on probation for nearly a year?
I go every Friday at 3:00.
You've been going every Friday?
I'm going for that. I'm going every Friday at 3:00, and for the substance abuse counseling, I'm going every Tuesday at 5. And I have AA meetings 3 times a week at 2:30 Saturdays and Sundays, and 7 p.m. on Wednesdays.
Okay, sir, when did you begin your batterers class?
Should I what?
When did you begin your batterers intervention class?
I got into that one January. I'm not sure what date.
Sir, I'm going to guess that you're not allowed to consume alcohol while you're on probation for either one of those, whether it's Third Circuit Court or 28th District Court in Southgate. Is that a good guess?
Yeah, that's correct.
Yeah, you are, with allegations of drinking again.
I know I have a problem.
Well, that seems to be pretty clear, sir, since now you are charged with a third offense, domestic violence. And now here we have your daughter and your brother as victims. Who was the victim on the other matter? From last year that you pled guilty on?
My ex-wife.
Would that be Layla's mom?
I'm sorry?
Would that be your daughter's mother?
Yeah.
Yes. Okay,
Yeah.
and the first one you had, sir, a couple years ago, who was the victim in that one?
That would have been the person that called this time. His wife, my brother's wife. Yeah.
Your sister-in-law.
Yeah.
So let's see, we have your ex-wife, your sister-in-law, and now your brother and your daughter that have all been victimized by you. And you're currently on probation for domestic violence second offense, where, well, who was the other victim in that matter? Because there were 2 charges and one was dismissed. So who was the other victim in that matter?
That one was with my ex-wife.
I understand that, but there must have been two victims because there were two charges. So who was the other victim?
She was the only one.
Did you have two charges? Was your daughter the other individual that was involved that time?
No,
No. Well, it shows on his criminal history, 2 felony assault with dangerous weapons charges and 2 domestic violence charges, second offense. One of those was dismissed and both felonies were dismissed from town. So I'm trying to ascertain who the other individual would have been as the named complaining witness on that one.
Unless, Your Honor, it may have been charged 2 counts against the ex-wife, as well as the felonious assault or EFA charges.
Okay, well, here's, Detective, as to bond recommendation.
Thank you, Your Honor. Unfortunately, I don't think the counseling and the drinking AA is working. I think it's more than reasonable for $5,000 cash bond each victim, so $10,000 cash. And if Mr. White posts, he is not to return. And he's to inform about his alternate living address, location, and contact number. Not to have any contact with the victims or witnesses in this matter. And not to have any additional cases, along with a GPS tether. Thank you, Your Honor.
Your Honor, we would ask for at least the opportunity to obtain a surety bond in this particular matter. I understand the $10,000, well, the total of $10,000 cash, but we'd ask that it also be cash and or surety.
You're asking for?
Rather, I'd ask for the 5,000, 10%, allowing him to post a total of $1,000, but the recommendation was for cash only. And I'm requesting that if the court will not make it a 10% bond, and at least it would be cash or surety.
Nope. No counsel. In fact, I'm considering not even allowing your client any bond, given the fact that he's currently on bond or on probation for domestic violence second offense. Now he has 2 counts of domestic violence. Now he has a third offense notice, and he's also on probation in the 28th District Court. And in both courts that he's currently on probation for, he's not allowed to consume alcohol, yet he is. And now he's back here. And now we have his daughter as a victim. And now we have his brother as a victim. And so he poses a significant danger to society. And his family members, quite frankly. The court's going to order a $100,000 cash bond, no surety, no 10%. In the event you think that you would like to have treatment inpatient, sir, you can certainly request that to the Wayne County Jail. Thank you. Have a good day.
You judge, you too.
thank you too.
All right, so that was that. I deleted a comment of Linus's in Discord, and she's asking me who the heck deleted her comment. She said no profanity in comments. Oh, she must have been talking about YouTube, so. Oh well, sorry about that, Linus. Yep, well, that guy hit the end of his rope. So, he's not going to get to keep playing that game, definitely not with Judge DeSanto. Her voice is great. I love her voice, but half the time I can't understand the damn thing she's saying. But I love her voice, though, so I'll keep playing her. Y'all keep watching, I'll keep playing her, so we're going to do that. Thank you guys so much. It's about that time. We'll be back tomorrow night. I'm going to try to do one in the daytime, but, I promised that before and never came through, so we'll see how that one works. All right, we're going to throw on the ending credits and get the heck out of here. Y'all have a good night. We'll see y'all tomorrow.